Hi again, it's Marcus here from Michles and Booth, and a big week last week for victims of medical malpractice claims in Florida. I've got here 100 pages worth of the Supreme Court of Florida's decision in McCall versus the United States. And this is a big deal for a lot of people, and it's a big deal for me, a big deal for our clients, and really a substantial decision as it impacts a lot of Floridians. In 2003, the state legislature passed caps that limit damages for victims of medical malpractice in the state of Florida. The Supreme Court of Florida struck down those caps last week in a very, very powerful decision with very interesting and very poignant, considerate, and very pointed language to victims and to the legislators that would pass these kinds of caps. The system in Florida worked kind of, in my opinion, backwards by withholding compensation from the victims of medical malpractice arbitrarily based upon an alleged crisis in the medical community. The argument in 2003 was that doctors were leaving the state, that they couldn't make enough money, that their malpractice premiums were so high that it was just an untenable workplace. The legislators, who in my opinion were greatly influenced by the American Medical Association and the Florida Medical Association lobbies, passed this legislation because in truth the numbers of people that get great health care far outweigh the number of people that suffer mistakes and the catastrophes of medical malpractice. With those kind of numbers, it's easy to pass protections for physicians. The reality, and by reality I mean the economic reality, is there is no such crisis in Florida. The numbers of physicians, as documented by the Florida Medical Association rosters, those numbers continue to increase. Why? Because Florida is a great place to live, but also because it's a great economic opportunity for physicians. Numerically, we know that the numbers of physicians are going up, and numerically we know the number of medical malpractice claims is going down. That's great news. Hopefully less mistakes are being made and hopefully less people are being injured. But this alleged medical malpractice crisis was very carefully studied by the Supreme Court of Florida and soundly rejected. After looking at the documentation and studying the economics of it, the Florida Supreme Court, in a 5-2 decision, with Justice Lewis authoring the majority opinion, found that there is no medical malpractice crisis in Florida, if there ever was. Now, on a personal note, let me tell you, I've been working on this for a long time. I was the chairman of the Florida Justice Association's Committee on Medical Malpractice. I chaired that committee for several years, and it seems like I worked pretty diligently in a losing cause over and over again to fight these legislators and this perception that there was this terrible community, this terrible environment for physicians. Look, here's what we know. If you drive a Mercedes, it costs a lot more to insure that car than if you drive a Volkswagen. You get the benefit of having the nicer car, and you get the burden of having to pay a higher premium to insure it. If you live out on the beach, you pay a higher premium for homeowners insurance than if you don't. You get the benefit of the beautiful environment, you get the burden of the higher risk environmentally, and those risks produce a higher and more expensive premium. That's economics. That's the economics of insurance. If you're a physician, you get the great benefit of doing this wonderful job to help people, and you get financially rewarded for that. I'm not saying it's unjust. I think it's absolutely just. Physicians and healthcare providers work extremely hard. They're dedicated professionals. They've dedicated their lives to study and academic excellence. They've dedicated themselves. They make personal sacrifices. That's not lost on me. The benefit is they get compensated well. The burden is because of the risks of their profession. If they make a mistake, the consequences can be devastating. That's where the benefit and the burden merge. Now, you don't have to be a scientist and you don't have to run a lot of empirical data. You can drive right up the street and take a photograph in the physician's parking lot and compare the cars in that photograph to the photograph that you take when you walk over to the patient's parking lot. You know, the one document that's always been missing from this analysis, the one document that could empirically establish whether it's fair or unfair, is the W-2. If you're a physician and you can't make ends meet in Florida, bring your W-2 in and lay it on the table and say, look, that's how much money I'm earning and it's not enough. Now that document has never been produced because it's crazy. Physicians are in the top 1% of reimbursed professions in this country. Healthcare corporations are in the top 3% of money-making corporations in this country. To say that you don't have a favorable economic environment is silly, and the Florida Supreme Court said so in their opinion. Here's the real fallacy about caps. If you decide that you want to subsidize an industry, for example, the healthcare industry, if you decide that the economic environment is so bad, okay, so be it. Let's do the analysis and let's weigh the economics. But when you decide to pass the hat to subsidize an industry, the one category of citizens that probably should get to say, hey, I'm not going to contribute, the one category of citizens that should get a pass on that subsidy is the category of people that are the victims of that industry. You know, if you and I say, you know, our doctors are good guys, our nurses are good people, we want to subsidize their income, we want to give them a pass so that they don't have to pay their malpractice premiums, we want to help them out, then let's do that. Let's pass the hat between me and you, and let's subsidize that industry. But if someone else gets hurt and loses a loved one, like a young mother in this McCall case that bled to death in front of the healthcare providers over many hours in Fort Walton Beach, that family should get a pass, right? If we're going to pass the hat and raise money to subsidize the healthcare community, that family ought to get, you know, a free pass, kind of like a tax exemption, right? But what caps do is they only tax the victims of the system. That's backwards. It always has been. Let me read to you a couple of passages just to give it a flavor of what the Supreme Court meant when it issued this ruling. It said, it has the Florida Statute 766, our Medical Malpractice Act. The court writes, has the effect of saving a modest amount for many, the healthcare providers, by imposing devastating costs on a few. Those who are the most grievously injured, those who sustain the greatest damage and loss, and multiple claimants for whom judicially determined non-economic damages are subject to division and reduction simply based upon the existence of a cap. The idea is that you can lower premiums slightly across the board, but the people that bear the burden of those premium reductions are the victims of medical malpractice. Until last week. So since 2003, the community of victims, and I'll be happy to acknowledge that that community is small, but it's real. Yesterday, I was approached by a family where a sponge was left in after a surgery. It abscessed, became infected, as it rendered that person almost completely an invalid. There is no question that malpractice occurred. I've represented a woman whose wrong breast was removed intraoperatively. I've represented a family where the medications were mixed up and they gave their family member the medication and killed their family member because the wrong medication was given. I've represented families where the wrong limbs have been removed. I've represented families where x-rays were exchanged and an open chest surgery was performed on a patient that didn't need it. Trust me, there are mistakes being made. But that's not the problem. The reality is there's wonderful things occurring in our hospitals and by our healthcare community, miracles being achieved every day. But that doesn't make them perfect, and when they make mistakes, it doesn't mean they're not responsible for the full measure of the mistake. You see, if you and I go out there and we run a red light and we cause an accident with significant or catastrophic injury, you and I are responsible for the complete measure of our mistake. We're responsible to make that right. Our insurance is responsible for making that right. There are no caps which arbitrarily limit our responsibility for our mistakes. There are only caps, were only caps, for physicians who made mistakes that were not going to be responsible for the complete measure of their mistake. This decision, the McCall decision by the Supreme Court of Florida, is a fantastic decision for victims, both past and future, of malpractice. But that's just the tip of its significance. Its significance is really that it says we are all capable of mistakes. We're human beings, but we are all responsible for our mistakes, and not a percentage, not an arbitrary number established by a bunch of lawmakers in a back room in closed circumstances. We are all responsible healthcare providers included, for the full measure of our damages. And ultimately, this reinstates a faith in our jury system. And I want to conclude by saying this. Juries don't get it right every time. Juries make mistakes. Citizens don't always do the right thing. We know that. It's human nature. But the jury system of this country remains the envy of all free countries because citizens decide citizens' fate. Citizens decide what the full measure of responsibility is. Not a government agent, not a municipal judge, not somebody appointed by the uncle of a friend of your next door neighbor, citizens. And a citizen jury is the backbone of measuring damages and measuring justice. So for my money, the McCall decision is about endorsing the jury system and letting the jury hear the evidence and make the best decision they can under the circumstances as to what the full measure of damages are. I'll bet some of you don't like what I've said, and I respect that. If you've got comments, give me a call. I'm happy to talk about it. But for me, for our practice, and for our victims, the McCall decision is a wonderful decision by the Supreme Court of Florida. I look forward to seeing you next week. I'm Marcus Michles from Michles & Booth. See you soon. And if you want to read more, go to forthevictims.com/blog.